Hello and welcome to this week's BizSmart Lunch and Learn webinar. Our weekly webinars are aimed to provide advice and share knowledge amongst business owners, and this is part of our service to our Smart Room members. If you're not already a member or a BizSmart client and would like to access our archive of webinars, then please visit our website biz-smart.co.uk and go to the Smart Room page. Our host joining me today is BizSmart Select member Katherine Hall. She is a solicitor at Haynes Solicitors. But before we start today's webinar, can I ask you all to use the question mark function on your screen to post any questions that you may have for Katherine, and she will do her best to answer them all at the end of the session. Thank you, Katherine. Over to you.
Okay, hi there. Company directors are under an obligation to comply with both fiduciary duties and statutory duties. This webinar will focus in particular on director statutory duties as set out by the Companies Act 2006. However, we will also touch briefly on the fiduciary duties and common law duties upon which these statutory duties are based. As mentioned, my name is Katherine Hall. I am a commercial property solicitor at Haynes Solicitors. In this webinar, I'm going to aim to provide an overview of the various directors' duties, how to remain in compliance, and the consequences should a director become in breach. This webinar should provide an introduction for those who are currently directors of limited companies and also those who are considering taking on the role of a director of a limited company. It's intended to provide a broad overview of concepts, and personal legal advice should of course be sought in relation to any specific case or matter. The Companies Act 2006 provides the general duties of directors, and this will be the primary focus of this webinar. I will be providing a detailed overview of what these duties are and how fundamentally important they are to any director of a company. However, the list of statutory duties codified within the Companies Act 2006 does not include all the duties a director can potentially owe to his or her company. Additional duties are provided elsewhere, while others remain uncodified. It is important to be aware that a breach in your duties as a director can result in you being held personally liable. Examples of this include conflicts of interest and fraudulent and wrongful trading. In extreme worst-case scenarios, directors can also find themselves subject to criminal investigation and prosecution resulting from breaches of regulatory compliance requirements, such as health and safety regulations. It is worth taking legal advice to ensure that your practice, policies, and procedures do not lead to a breach of your duties as a director. As some listeners may not yet be directors and may be in the stage of thinking about setting up a limited company, I thought it may be helpful to cover some of the basics in regards to shareholders versus directors before we move on to the specifics of directors' duties. A limited company protects its shareholders from personal liability as it is a legal entity separate from its owners. A company acts through two bodies of people, the shareholders and the board of directors. First, I'll discuss the shareholders. The owners of a company are called the shareholders, and they stand to lose only the amount they have invested into the limited company. Their liability is limited to their shares. Of course, there are some exceptions, which are not within the scope of this webinar. The shares held by a shareholder come with specific rights. These rights can be varied, but they generally include voting rights, as shareholders are the ultimate decision makers, rights to dividends, which are assets paid out of the company's profit, and rights to return in capital, which is return on investment. While shareholders aren't involved in the day-to-day running of companies, their voting rights allow them to exercise ultimate control over the company and its management. There are certain acts that must be done by shareholders. For example, removal of directors from office and changing of the company's name. Different acts will require different shareholder voting majorities. Unlike shareholders, directors are responsible for the day-to-day management of the company. There are certain requirements for directors. A company must have at least one director. At least one director must be a natural person, an individual rather than a corporate entity, and a person must be at least 16 years old to be appointed as a director. Some people are disqualified from being directors. For example, you would be disqualified if there are bankruptcy proceedings ongoing against you, or if you have been disqualified by the courts for reasons such as failing to keep company records or persistent breaches of company laws. You can be both a shareholder and a director, and if you are setting up your own company, you are often going to be both a shareholder and a director. However, there is no requirement that directors be shareholders or that they be chosen by shareholders. The basic rule is that directors should act together as a board. However, in practice, the board can delegate certain powers to individual directors or board committees. There are different types of directors, and I will cover these before moving on to duties. It is worth noting that being registered at Companies House as a director is not the sole deciding factor as to whether you are accountable as a director and can be held responsible by a court for breaching director duties. If you are undertaking and performing the duties which a director would typically perform, you could be viewed as a director regardless of whether you are called a director. The test to keep in mind is, do you have direct influence and control over the direction of the business and the people working within the business? In determining who is a director, a court will focus on the acts of the individual, not on their title. The question is, are you carrying out responsibilities typically carried out by directors? The definition of a director can be found in Section 250 of the Companies Act 2006. This states the following: director includes any person occupying the position of director by whatever name called. This can also include a shadow director or a de facto director, both of which I will discuss in more detail below. In practice, the day-to-day management and running of a company is often conducted by a person who is not considered by a company to be a director, a person that is often not officially registered at Companies House as a director of the company. There is often a misconception that if you are not formally appointed and registered as a director, you will not be held accountable in regards to compliance with any director's duties. This is very much not the case. As mentioned previously, the breaching of director's duties can potentially expose a person responsible to personal liability, which can result in onerous sanctions. As such, it's important to be aware of the various types of directors and the circumstances in which you may be responsible as a director and liable for breaches. The first of these would be an executive director. This is a director who takes care of the business of the company on a day-to-day basis. This is usually a full or part-time employee. This would typically be the category where a sole director of a company would fall, although the term is more often used in larger companies. A non-executive director is a director who is not an employee and therefore does not work for the company each day necessarily, but may come in and meet once a month. Their role is to ensure that the company is run by the executive directors to an appropriate standard and to look after the corporate governance of the company. They are not typically given specific responsibility for the management of any specific company aspects. The legal duties of these two types of directors, executive directors and non-executive directors, are the same, but in practice, application of the duties can vary. A de jure director is a person who has been officially appointed as a director, elected at a general meeting or appointed by the board, and registered as a director at Companies House. On the other hand, a de facto director is a person who has not been formally or officially appointed or registered at Companies House, but who carries out the duties of a director and makes decisions. This is where the definition of any person occupying the position of a director by whatever name called, as defined in Section 250 of the Companies Act 2006, would come in. A shadow director, on the other hand, unlike the previous definitions, is regulated by the Companies Act 2006 and specifically defined within the Act as a person in accordance with whose directions or instructions the directors of a company are accustomed to act. This can be an individual or it can include a legal person such as a company. To put this into simple terms, it means that a person can be considered as a director by a court if the majority of the board acts in accordance with that person's instructions. Case law has held that the board must do something in compliance with the person's instructions for him or her to be a shadow director. The mere giving of instructions does not make someone a shadow director. It is worth noting that shadow directors are deemed directors for purposes of wrongful trading under Section 214 of the Insolvency Act 1986, and in this case they may become personally liable for the debts of an insolvent company. One cannot avoid directors' duties simply by avoiding official appointment. Under the Companies Act 2006, the general duties we will discuss apply to shadow directors where and to the extent that they are capable of so applying. The next question to consider would be, to whom is the duty owed? To whom does the director owe the duty? The Companies Act 2006 makes it clear that the duties are owed to the company. As such, it is only the company which can enforce performance or seek remedy for breach, which we will discuss later. There is an exception to this called a derivative action, which I will also touch on briefly later in the webinar. This also does not prevent a shareholder from bringing an action against a director in relation to a separate legal relationship, perhaps arising where a director has made a material representation to a shareholder. But again, this is not in the scope of this webinar. In cases of insolvency, there will also be a duty to creditors. Now we will discuss the general duties. There are 7 general duties imposed on directors in accordance with the Companies Act 2006. These are the duties a director owes when exercising his or her powers as a director. As mentioned previously, the Companies Act 2006 incorporated certain common law and equitable duties. The first of these 4 duties came into force on 1st October 2007, and the remaining 3 came into force on 1st October 2008. These statutory duties under the Companies Act 2006 are seen as replacing the common law and equitable duties from which they were derived or upon which they are based. Companies Act 2006 states that the statutory duties shall be interpreted and applied in the same way as the common law rules or equitable principles, and regard shall be had to the corresponding common law rules and equitable principles in interpreting and applying the duties. The Act, however, does not state that the common law rules no longer apply. As such, I will briefly cover some of the major fiduciary duties directors owe to the company within the discussion of the statutory duties. Please note that this webinar focuses on directors' general duties as set in Chapter 2, Part 10 of the Companies Act 2006. As mentioned previously, there are various other duties that also apply to directors, which will not be covered in depth today, such as those under the insolvency legislation, health and safety law, and duties towards employees, among others. The statutory duties, or the general duties, as set out in the Companies Act 2006 are as follows. Duty to act within powers, duty to promote the success of the company, duty to exercise independent judgment, duty to exercise reasonable care, skill, and diligence, duty to avoid conflicts of interest, duty not to accept benefits from third parties, and the duty to declare an interest in a proposed transaction or arrangement. The first of these, the duty to act within powers, is set out in Section 171 of the Companies Act, and it states that a director of a company must act in accordance with the company's constitution and only exercise powers for the purpose for which they are conferred. So what exactly is the company's constitution? These are the rules that govern the operation of a company. Under Part 10 of the Companies Act, the company's constitution is defined as the company's articles, decisions taken in accordance with the articles, and other decisions taken by the members or a class of them if they can be regarded as decisions of the company, and any resolutions and agreements affecting a company's constitution. These would include the following, but are not limited to, the company's articles of association and any resolutions of the company, including special resolutions, or any resolutions or agreement which bind shareholders. It includes the company's shareholders' agreement, if there is one in place, and it includes any joint venture agreements. Section 171A of the Companies Act 2006 requires a company's directors to follow company rules and limitations regarding how the company's affairs should be conducted. This would imply that directors must review and understand their company's constitution. Section 171B of the Companies Act, which codifies the common law rule that directors' powers are used only for the purposes for which they were conferred, is known as the proper purposes doctrine. Courts developed this doctrine so that directors would use their powers only for the purposes intended by the company and only in ways consistent with the company's interests. The key here, and the emphasis, is the exercising of the powers for proper purposes rather than a provision of limits on the authority to act. Examples of exercising powers for an improper purpose would be the same as those that existed in common law, such as where a director acts for reasons relating to the protection or advancement of his own interests or position rather than purposes relating to the company's interests for which the powers were intended, or where a director acts to exercise influence over the outcome of a general meeting or acts with the purpose of causing difficulties for a particular shareholder. For example, if a director were to use its authority to attempt to sway the decision at a shareholders' general meeting, this would be an improper use of power, as the shareholders are the decision makers under the company's constitution. It is important to note that a director can be found to have exercised his powers for improper purposes, even where he or she believed he was acting in good faith and in the best interest of the company. In practice, this duty and its breach are dealt with very much on a case-by-case basis by courts, as it is difficult to establish fixed rules as to what is a proper purpose versus an improper one. As with all directors' duties, it is advisable to seek personal legal advice when faced with a situation where what constitutes a proper act of a director is uncertain. The second general duty is the duty to promote the success of the company. This duty is considered the most fundamental of the general duties and is considered to be based on the common law fiduciary duty to act in good faith and in the best interest of the company, and on a statutory duty to consider the interests of employees as provided under Section 309 of the Companies Act 1985. Section 172 of the Companies Act 2006 states the following: a director of a company must act in the way he considers, in good faith, would be the most likely to promote the success of the company for the benefit of its members as a whole, and in doing so have regard, amongst other matters, to A, the likely consequences of any decision in the long term, B, the interests of the company's employees, C, the need to foster the company's business relationships with suppliers, customers, and others, D, the impact of the company's operations on the community and the environment, E, the desirability of the company maintaining a reputation for high standards of business conduct, and F, the need to act fairly as between members of the company. The first clause, setting out that a director must act in a way he considers in good faith to promote the success of the company, has caused some uncertainty in application, and it leaves room for interpretation. In simple terms, success is interpreted as a long-term increase in value. This meaning and the means of achieving it have been viewed as being up to the discretion and judgment of a director of a company, providing that the director has acted in good faith to make a decision that is appropriate for the company. This means that an honest business decision, although leading to failure, would not give rise to a breach of this duty. The second portion of Section 172 of the Companies Act 2006 sets out the matters a director must take into account when making decisions. A director must consider these factors to promote the success of the company. However, this list is not exhaustive in terms of what a director must take into account, as it also states they must have regard to other matters. Companies can also add additional purposes by setting these out in their constitution. Section 172(2) of the Companies Act 2006 states as follows: where or to the extent that the purposes of the company consist of or include purposes other than the benefit of its members, subsection 1 has effect as if the reference to promoting the success of the company for the benefit of its members were to achieving those purposes. It's worth noting that under Section 172(3) of the Companies Act, the duty imposed by this section does not override any laws which require directors to act in the interests of creditors of the company. This is a point in relation to insolvency and, although important, will not be discussed further for the purposes of this webinar. The third duty is the duty to exercise independent judgment. Section 173(1) of the Companies Act 2006 provides that a director of a company must exercise independent judgment. This duty is not infringed by his acting, A, in accordance with an agreement duly entered into by the company that restricts the future exercise of discretion by its directors, or B, in a way authorized by the company's constitution. This states that the director must exercise independent judgment. In other words, they must make their own decisions. This would preclude a director from entering into agreements in regards to how they will vote with third parties. The director, however, will not be in breach of this duty if they've acted in agreement with the company's constitution or in accordance with agreements entered into by the company, which do have the effect of restricting the exercise of the director's discretion. This allows a company's shareholders to influence the director's use of powers by entering into an agreement which affects their exercise of powers. The fourth duty is the duty to exercise reasonable care, skill, and diligence. Section 174 of the Companies Act 2006 provides as follows: A director of a company must exercise reasonable care, skill, and diligence. This means the care, skill, and diligence that would be exercised by a reasonably diligent person with A, the general knowledge, skill, and experience that may reasonably be expected of a person carrying out the functions carried out by the director in relation to the company, and B, the general knowledge, skill, and experience that the director has. This duty includes both objective and subjective tests. The objective test is that the director must have the knowledge, skill, and experience to do the job. And in cases where a director has specialist knowledge, the higher subjective standard must be met. Therefore, it goes without saying that a directorship should not be taken on unless one is properly qualified and has the experience to carry out the duties as reasonably expected of a director for that particular company. An experienced or highly qualified director must be able to exercise a high level of skill and expertise. The law has accepted that it is not realistic or practical to expect a director to carry out all duties, and therefore delegation is allowed for. However, a director must keep in mind that he or she will be held to a standard in regards to the person or entity to which they delegate or outsource this matter. And the director should work to stay informed in regards to the carrying out of any delegated duty to ensure necessary standards are being met. The fifth duty is the duty to avoid conflict of interest under Section 175 of the Companies Act 2006. This section states that a director is required to avoid situations where a conflict with the interests of the company exists or may arise. Duty to avoid conflict of interest means that without the permission of the company, a director cannot put themselves in a position where there is a chance of conflict in relation to the duty the director owes to the company. I will, for clarification, provide you with some examples. Section 175 of the Companies Act 2006 provides as follows. A director of a company must avoid a situation in which he has or can have a direct or indirect interest that conflicts or possibly may conflict with the interests of the company. This applies in particular to the exploitation of any property, information, or opportunity, and it is immaterial whether the company could take advantage of the property, information, or opportunity. This section is based on the long-standing common law rule that directors must not abuse the trust placed in them. A director must put the interest of the company first and not seek to put their own personal gain before the interests of the company. The test of Section 175 of Companies Act is an objective test, which means a director can find themselves in breach without being aware of the conflict. As such, for the duty under this section to have been breached, it is not necessary that there is a situation where a director knew the act they were doing was a breach of this section. There are a number of ways in which a conflict of interest could arise. Below are some examples of situations in which a conflict of interest may occur. This could occur when there's more than one directorship. But, for example, this would apply in cases where a director serves on another board where potential for conflict may arise. Perhaps this would be the board of a competing company or a company that the company works with, for example, a supplier or a customer. Conflict could occur where the director is a major shareholder of the company, or perhaps if the director is a potential customer or a potential supplier to the company. Conflict could also occur where the director owns property adjacent to the property owned by the company and therefore has an interest in activities the company is carrying out on its own property. Conflict could arise where the director is a director of the company's pension trustee company. There's also always other personal conflicts to keep in mind. Perhaps there's an instance where a director has a personal interest, such as a shareholding in a competing company. There could also be situations where information gained as a director could be used to seek personal profits, or advisory positions are also an area where a conflict can arise. For example, if a director holds an advisory position in another field within the company or for a competitor company. Should a conflict of interest situation arise, a director should check with the board members. Should the board members not have the authority to approve or authorize the conflict, then it should be referred to the shareholders for consideration. The company's articles of association may also contain provisions in regards to conflicts of interest, which should be reviewed. The sixth duty under the general duties is the duty not to accept benefits from third parties. This ties in obviously to the previous duty. Under Section 176 of the Companies Act 2006, a director of a company must not accept a benefit from a third party conferred by reason of his being a director or his doing or not doing anything as a director. This duty is not infringed if the acceptance of the benefit cannot reasonably be regarded as likely to give rise to a conflict of interest. Any reference in this section to a conflict of interest includes a conflict of interest and duty of conflict of duties. In simple terms, what this means is that a director should not accept a benefit from a third party, either for doing something or from abstaining from doing something as a director of a company. As stated, this duty is not breached if the director's acceptance of the benefit cannot reasonably be regarded as likely to give rise to a conflict of interest. It's important to note that authorization by the board cannot enable a director to accept benefits from a third party. It would be good practice to have policies in place in regards to accepting gifts. You should note that if a person's directorship has ended, this duty will continue in relation to things done before the directorship came to an end. The seventh duty is the duty to declare interests in proposed transactions or arrangements with the company. This duty is set out under Section 177 of the Companies Act 2006, which states, if a director of a company is in any way directly or indirectly interested in a proposed transaction or arrangement with the company, he must declare the nature and extent of that interest to the other directors. The section sets out how the declaration should be made and states that if a declaration of interest under this section proves to be or becomes inaccurate or incomplete, a further declaration must be made. Any declaration required by this section must be made before the company enters into the transaction or arrangement. This section does not require a declaration of an interest of which the director is not aware, or where the director is not aware of the transaction or arrangement in question. For this purpose, a director is treated as being aware of matters of which he ought reasonably to be aware. A director need not declare an interest, A, if it cannot reasonably be regarded as likely to give rise to a conflict of interest, or B, to the extent that the other directors are already aware of it. And for this purpose, the other directors are treated as aware of anything of which they ought reasonably be aware. This duty further reinforces the duty to avoid conflicts of interest, as it aims to achieve transparency in relation to personal interests which might affect a director's actions in their carrying out of their duties. For this duty to apply, the director does not have to be a party to the transaction. It's worth noting that a duty may also arise where a third party's interest is related to a director's interests. It is best practice for a director to carry out due diligence in relation to the connected person's interest and to seek legal advice should any potential interest conflict arise. Please note that Section 177 only concerns transactions or arrangements that are being proposed. However, please note where there is a transaction or arrangement already in existence, this must be declared as soon as it is reasonably practicable. A failure to declare such an interest can give rise to a criminal offense. Although, as stated, no declaration is required in some circumstances. For example, if it cannot be reasonably regarded as likely to give rise to a conflict of interest, or if the other directors are already aware or reasonably ought to be. This concludes the discussion of the general duties which are codified in the Companies Act 2006. As discussed earlier, English law imposes a number of additional specific duties on companies' directors. For example, director duties have been provided for in the Insolvency Act 1986, the Insolvency Act 2000, and the Bribery Act 2010. In addition, duties arise under statutes which are generally applicable to almost all businesses, including tax, employment, and health and safety, and also under those that might apply to a company's particular area of business activity or specific status of structure. One's trade association would be a good starting point for learning more about what duties you might need to pay attention to. Many of these statutes impose personal liability, including criminal liability, on directors who are found guilty of noncompliance. Accounting and reporting duties is another important area to note where duties arise. Directors are tasked with the obligation to ensure a company remains in compliance with the various accounting and reporting requirements set out by Companies Act 2006. So what happens if the duty has been breached? A breach of duty may be grounds for the termination of an executive director service contract or for disqualification. As discussed previously, the general duties are owed to the company and not to the shareholders of the company. As such, if civil proceedings are brought, it will be the company which brings the enforcement action against the director where a duty has been breached. Or in cases of insolvency, it is for the liquidator or administrator of the company to bring proceedings against the director. However, there may be cases where shareholders can bring what's called a derivative action against a director on behalf of the company where the director has breached a duty. A court may choose to refuse a derivative action where a director was acting pursuant to his or her duty to promote the success of the company in accordance with Section 172, or where the cause of action arises from an act or omission that has been authorized by the company. It is important to be aware of the duration of the general duties, which is something I'd like to comment on. A director's duties begin when they become a director, which may require some consideration in regards to directors not formally appointed. However, resigning from a director role does not mean a director's duties all come to an end. Although in general, the general duties discussed above do come to an end, there are exceptions. These are set out in sections 175 and 176 of the Companies Act, which you'll remember deal with conflicts of interest and accepting benefits from third parties. Section 172 of the Companies Act 2006 states, a person who ceases to be a director continues to be subject A, to the duty in Section 175, duty to avoid conflicts of interest, as regards the exploitation of any property, information, or opportunity of which he became aware at a time when he was a director. And B, to the duty in Section 176, duty not to accept benefits from third parties as regards to things done or omitted by him before he ceased to be a director. Another point worth noting in regards to the general duties is that if more than one duty applies, directors have to comply with each duty. Section 179 of the Companies Act 2006 deals with this. This is an important mention as a director cannot breach any law in complying with a duty. Further duties can be imposed on directors other than statutory duties. This can be done by the company's articles. Next, we will take a quick look at remedies. Where the duty of care, skill, and diligence has been breached, the normal remedy is damages. Breach of other duties can be injunctions, restoration of the property of the company, and compensation. Directors, of course, do need to be careful, as mentioned previously, because certain breaches do carry criminal sanctions. In regards to what relief there is if a duty has been breached, where a director is in a situation that the duty owed to the company has been breached, there are various options available. The first is ratification. Section 239 of the Companies Act 2006 provides in certain cases the shareholders of the company can by resolution ratify the breach. Section 239 states the following. 1. This section applies to the ratification by a company of conduct by a director amounting to negligence, default, breach of duty, or breach of trust in relation to the company. 2. The decision of the company to ratify such conduct must be made by resolution of the members of the company. This basically allows for breaches to be forgiven. There are certain procedures that must be followed for ratification, and not all acts can be ratified. For example, fraudulent acts cannot be ratified. Another form of relief would be relief granted by the court. Section 1157 of Companies Act 2006 provides where proceedings are brought against a director for negligence, default, and breach of duty, the director may be released from liability if they have acted reasonably and honestly, having considered all the circumstances of the case. This section states the following. 1. If in proceedings for negligence, default, breach of duty, or breach of trust against A, an officer of the company, or B, a person employed by a company as an auditor, whether he is or is not an officer of the company, it appears to the court hearing the case, the officer or person is or may be liable, but that he acted honestly and reasonably, and that having regard to all the circumstances of the case, including those connected with his appointment, he ought fairly to be excused, the court may relieve him, either wholly or in part, from his liability on such terms as it thinks fit. If any such officer or person has reason to apprehend that a claim will or might be made against him in respect of negligence, default, breach of duty, or breach of trust, he may apply to the court for relief, and the court has the same power to relieve him as it would have if it had been before a court before proceedings against him for negligence, default, breach of duty, or breach of trust had been brought. In summary, a court may offer relief if it considers the director to have acted honestly and reasonably, and considering all the circumstances, the court decides he or she ought fairly be excused. Insurance is also another important consideration. It can be arranged for the directors and officers, and this is generally considered best practice. Insurance can be purchased by the company to protect directors from liability in relation to negligence or breach of duty by them arising from their acting as a director to the company. Indemnity is also a subject for consideration. A company can indemnify directors against personal liability, but there are limits as to what indemnity can cover. For example, indemnity cannot cover fines for criminal conduct or regulatory breaches, and it can only cover liability to third parties, and it is not applicable where the company is suing the director for breaches. Examples of where an indemnity can be given include costs of damages awarded against a director and civil claims brought by third parties, legal costs if a director is acquitted in legal proceedings, and costs in fighting certain civil proceedings. It is important to note that these indemnities should be provided for in the director's service contract or other document and not just in the company's articles. That concludes the webinar, and I hope it has provided a basis for understanding the role of directors' duties. Again, this is intended to be an overview, and if you have any concerns or queries in regards to a specific matter, personal legal advice should be sought. Thank you.
Okay, thank you very much. Let's see if there's any questions for you. Yeah, thank you. Your first question is from Katherine, and she asks, what can I do if, as a director, I think there may be a conflict of interest in something being actioned by the company?
Okay, with conflicts of interest, it's important to note that you can breach the duty to avoid a conflict of interest even if you believe yourself to be acting in the company's best interest. So wherever you as a director have any question as to whether there may be a conflict, you should really not take the action from which the conflict would arise, or you would need to obtain authorization to act from the board or the shareholders. Obviously, if there's a question and you have concerns and the solution isn't clear, you should seek legal advice. It's also worth noting that directors are not under a duty to avoid interests in relation to transactions with the company itself, but you still need to disclose these. You have a duty to disclose these to the company. Again, the duty to avoid a conflict of interest is a duty that continues post-resignation, so it's something you always need to keep in mind.
Okay, thank you. You have another question. This one is from Steve, and he asks, in relation to the accounting and reporting requirements briefly mentioned, what returns or filings must be made to Companies House?
Okay, from 30th June 2016, there's a requirement to at least once a year review and then confirm to Companies House that the information it has on file in regards to your company is accurate. This is achieved by filing a confirmation statement, and this is a replacement of what was previously called the annual return. There's also a requirement to annually file a copy of your company's annual report and accounts at Companies House. There's penalties for late filings, so you do need to be aware of your company's due dates. Often directors and shareholders work closely with their accountants in relation to these. Other filings which must be made with Companies House include such things as changes to the Articles of Association, any director appointments or resignation, changes in directors' details. The same goes for secretary appointments, resignations, or changes in detail if the company has a secretary. Changes to the registered office of the company, certain shareholder resolutions would need to be filed, changes to the company's accounting reference date, and changes to the company's share structure or issues of shares, and also charges or debentures that the company might be granting. And again, many companies do hire third parties, such as an accountant or solicitor, to handle these kind of filings. Some can have particularly onerous consequences if you do fail to file. For example, a charge would be a very important one to make sure it's timely filed. And again, as mentioned earlier, if a director's duties in relation to this type of thing aren't met, if they are outsourced and they aren't met, the duty does still remain. You don't discharge your duty by outsourcing it.
Okay, thank you. We have another question from Stuart this time, and he asks, what is required in terms of board meetings and keeping of board minutes?
This is a question we get often, and I think the most important thing is just to be conscientious. It's best practice to hold board meetings throughout the year and to keep accurate minutes of those meetings. And this helps you to demonstrate your compliance with your duties if any sort of issue does arise. In general, you'll need to hold a board meeting whenever a decision must be made which requires board approval. You must also hold a board meeting if a director requests one. And you need at least one board meeting a year so that the annual accounts can be approved. Board meetings are a bit different. Unlike shareholders' meetings, they're not regulated by the Companies Act in such detail. But the Companies Act does require that minutes be kept, and there are some rules probably for conducting board meetings in your Articles of Association, which you should always refer to and be familiar with as a director.
Okay, I think that those are all your questions.
Great, thank you.
Thank you very much, Katherine, for hosting today's webinar. I will be sending out a copy of the presentation and Katherine's contact details out to you all very shortly. So please do email any further questions you may have direct to Katherine. Before we close, just a quick reminder, this webinar is part of our service to our Smart Room members. If you're not already a member or a BizSmart client or would like to access our archive of webinars, then please visit our website, biz-smart.co.uk, and go to the Smart Room page. That's the end of today's webinar. Thank you all for listening, and we hope you can join us again very soon.